All right, welcome back. This is presentation 3 of federal courts. Let's jump into it. Judicial review of federal agencies, that's an important aspect of the Supreme Court and the federal judiciary's power of judicial review. The rise of the administrative state to manage the thousands of federal programs produces a considerable amount of what we, in bureaucratic politics, we call administrative discretion, where you have basically non-elected people wielding congressional powers in oftentimes ways where accountability is difficult to ascertain. The idea of Chevron deference is an important concept that describes the federal court's basic sense in which they're going to defer to experts unless there's clear evidence that they're exceeding their authority. And the idea of Chevron deference comes from the Supreme Court case Chevron USA Incorporated versus Natural Resources Defense Council. It's a 1984 decision, and it involved a challenge to the United States government's interpretation of the word source in an environmental statute, and vagueness in the language of amendments to the Clean Air Act of 1963 in 1977 to target states that had not attained clear air standards. The Reagan administration's director of the Environmental Protection Agency, headed by Ann Gorsuch, who was the mother of Neil Gorsuch, the current Supreme Court justice, had loosened the rules to allow existing energy plants to get permits for new equipment that didn't meet previous EPA standards. The court's rule on the scope of administrative discretion is that courts should be deferential so long as the rules do not violate Congress's express or implied intent. Now, again, this was a situation where you had a conservative administration doing something conservative that was permissive for the manufacturing industry. But today, many conservatives believe that the court's deference to bureaucratic agencies it's mistaken, and that administrative discretion needs to be significantly curtailed. And we actually, I think, have a case that may clarify that situation in the short term. Judicial review and presidential power. The judiciary, again, usually upholds assertions of presidential power in realms like foreign policy, war, and especially in emergency powers. Two important cases kind of delineate the scope of presidential authority in the realm of foreign policy. In the United States versus Curtiss Wright Corporation, 1936, the Supreme Court upheld the president's authority to impose an arms embargo in attempting to resolve a war between Paraguay and Bolivia in Latin America. The court ruled that the president of the United States was the sole organ of foreign policy. However, about 18 years later, in Youngstown Sheet and Tube Corporation versus Sawyer in 1952, the Supreme Court struck down Harry Truman's executive order seizing American steel mills in the midst of the Korean War, arguing that the president lacked the authority to seize private property in the absence of a congressional authorization. The Bush administration produced several Supreme Court decisions placing limitations on presidential authority. For example, in Hamdi versus Rumsfeld in 2004, the Supreme Court ruled that Yasser Assam Hamdi, as an American-born citizen, was entitled to a lawyer and a fair opportunity to rebut the government's factual assertions. While the court asserted that it could review and place some constraints on the president's power, it also affirmed that the president had unilateral power to declare individuals, including citizens, enemy combatants who could be, detained under adverse legal circumstances. The Supreme Court also constrained presidential power during the Obama administration when Obama attempted to use recess appointments to the National Labor Relations Board when the Senate, which was at the time controlled by the Republicans, was refusing to allow those appointments. They were basically just not holding confirmation hearings. The court at that point held that the Senate's use of pro forma sessions where they simply gavelled in and gavelled out of session, that was constitutional. Likewise, during the Trump administration in 2018, the Supreme Court upheld Donald Trump's travel ban on people from Muslim-majority countries, despite, and again, this was a situation where Trump had promised to, impose a Muslim ban, which most constitutional scholars said on the face of it was, unconstitutional. He issued such an order, when he was sworn into office in 2017, but it was immediately enjoined in federal court on the grounds that the travel ban constituted a violation of the First Amendment. It was basically viewpoint discrimination, that you're discriminating against someone because they're Muslim. In Trump v. Hawaii, the Supreme Court held in a 5-4 decision the president enjoyed broad latitude to control travel in the interests of national security. Dissenting justices Ginsburg and Sotomayor accused the majority of ignoring the clear evidence of religious intent inherent in Trump's executive order, arguing it leaves undisturbed a policy first advertised openly and unequivocally as a total and complete shutdown of Muslims entering the United States, because the policy now masquerades behind a facade of national security concerns. Most cases reach the Supreme Court through appeal. Again, the point being that the Supreme Court very rarely hears cases that are based on their original jurisdiction. And in fact, most cases are appeals, appellate in nature. The Supreme Court couldn't do its job of adjudicating over millions of legal disputes unless it could control the flow of the cases. So today, the court has developed a process for controlling its caseload, and there are basically 3 filters that have to be overcome in order to get a case in front of the court, and that's one of the reasons why fewer than 100 cases, annually are really heard. The first one is cases and controversies. The second is standing, and the third is mootness, and we'll talk about each of these in turn. Cases and controversies, again, Article 3 of the Constitution and the Supreme Court's decisions define judicial power as applying only to cases and controversies and not to political questions. Again, in there, the meaning of the phrase is that a case brought before the Supreme Court must be an actual rather than a hypothetical controversy. This closes the federal courts off from acting as an advisory body to either Congress or the executive branch. Even after laws are enacted, the courts will generally only rule on its constitutionality until a case is implemented. The second of these is the idea of standing. Standing refers to the right of an individual to initiate a court action based on having a substantial stake in the outcome. Standing generally means that an individual or group can demonstrate clear harm by an action or an inaction of government. Therefore, an individual or group having a general interest in the outcome of a case is not enough. And again, the court has been criticized in recent days for basically sweeping that aside and allowing people with very tangential interest to nevertheless file appeals. Mootness is the third criterion, and it refers to a category used by the courts to screen cases that no longer require a resolution. Mootness effectively disqualifies cases that are brought too late and have been resolved by other means, or where the relevant facts of the case have fundamentally changed. Writs are an important aspect of the judicial process. Most cases appealed to the Supreme Court take the form of a writ of certiorari. Certiorari is Latin for to make more certain. A writ of certiorari is a court order by the Supreme Court or a superior court to deliver documents related to a case under appeal. Individuals who lose a case in federal or state court and want the Supreme Court to review the decision have 90 days to file a petition for a writ of certiorari with the clerk of the Supreme Court. Under the rule of 4, at least 4 Supreme Court justices need to agree to hear a case under appeal. Cases viewed as deserving review are often described as cert-worthy. Thousands of petitions for writs of certiorari are filed with the court every year. Since 1972, most justices participate, the justices' clerks actually participate in what is known as a cert pool, where the clerks distribute all the writs, the appeals, the petitions for writs of certiorari, and then write one-page summaries that describe the central, controversies within a case. So this slide basically shows you the number of cases that are filed with the Supreme Court each year. And again, if you look at it, in the 90s and 2000s, it kind of reached the high water mark of just over 9,000. These days, it's a little bit over 6,000. And again, to some extent, this is deliberate. The Supreme Court basically is saying, we like the way the law is. We're not, too hot to change things dramatically, and so we're most likely to refuse most appeals. Other avenues for appeal. Few cases, 80 or fewer, gain support for a full Supreme Court hearing. A handful of cases reach the Supreme Court by other means. Writ of certifications can be used when the U.S. Court of Appeals asks the Supreme Court for instruction on a point of law that hasn't yet been decided. Writ of appeals are used to appeal a decision from a 3-judge district court. And that would be an instance where they're basically bypassing the idea of an en banc appeal. The indigent also have recourse to file what is known as a writ in forma pauperis, which is Latin for in the manner of a pauper. And that signals a request from an individual who lacks the means to pay filing fees for appeal. Most appeals from prison take that form. So, who participates? These are the judicial methods of selection at the state level. And if you look, most states do what really looks a lot like what happens at the federal level, where the governor nominates, and then there is some sort of confirmation process. I want to say, is it Oklahoma? Yeah, Oklahoma has the governor appoints, usually from a nominating commission. Okay, there are also just straight up gubernatorial appointments. South Carolina, my former home state, uses legislative selection, and then there are some more democratic means through nonpartisan election. I will tell you, as a personal matter, I think that nonpartisan election of judges is a bad idea. Placing judges in the position of campaigning leads them to make promises that put them in a bad position to impartially judge cases, especially where you have powerful economic interests routinely being brought into court. Who participates? Judicial selection methods, again, as a regional view, you can see most of the Midwestern states use that gubernatorial appointment method. Partisan elections are used in some states. Alabama is famous. That was a state that got Karl Rove into politics, running judicial elections. So beyond the justices, there are a number of key players in the federal court process. One is known as the Solicitor General. That person is the third-ranking official in the Justice Department and is the top government lawyer in all cases argued before the Supreme Court. The Solicitor General exerts strong influence over the screening of cases that any federal agency wishes to appeal to the Supreme Court. The Solicitor General can engage on a case even when the federal government is not a direct party to it by filing an amicus curiae or friend of the court brief. Courts members, the justices, often give special attention to the way the Solicitor General characterizes an issue. Owing to the frequency with which Solicitor Generals argue cases before the court, they're often described as the ninth and a half justice. And in the past, some Solicitor Generals have enjoyed very close relationships with individual justices. For example, Ted Olson, who served as George W. Bush's Solicitor General, was close friends with Associate Justice Antonin Scalia, and the two often went on family vacations together. Likewise, Joe Biden's nominee, or the current Solicitor General, Elizabeth Prelonger, clerked for Associate Justices Ruth Bader Ginsburg and Elena Kagan. You also have law clerks, and again, each federal judge employs law clerks to research legal issues and assist in the preparation of opinions. Each justice is assigned 4 clerks. Clerkships with federal judges is nearly always considered a high honor within the legal profession and a major credential for law school graduates. Clerking for a Supreme Court justice is the highest of such honors, and justices generally select their clerks each session from top graduates of the best schools in the country: Harvard, Yale, the University of Chicago, the University of California, at Berkeley, etc. In the South, it's Vanderbilt and Emory University. The relationship between justices and their clerks is a closely guarded secret, but justices clearly rely heavily on their clerks. There's a former clerk to the retired Associate Justice Harry Blackmun named Edward Lazarus, who wrote a tell-all book, Closed Chambers, in 1998, accusing the justices of yielding excessive power to immature, often ideologically driven clerks, who in turn use that power to manipulate their bosses. So again, these are some of the important issues related to and some of the important players within the legal system. When we come back, we will continue and we will finish our presentation of Chapter 13, the federal courts. I'll see you next time.